Greetings. I hope that you and your loved ones are in the best of health and in good cheer amid these trying times caused by the coronavirus pandemic. This recording is made for the benefit of my second year JMC College of Law students to supplement the review of the first exam on the rules on civil procedure. And in this recording, I will be discussing the preliminary matters and general principles with respect to the rules on civil procedure. And just a kind reminder that this is merely a review, and as such, the discussions herein are not comprehensive. Alright, let us proceed. Now, preliminarily, perhaps it would be prudent to first define what is remedial law. Remedial law is a traditional term given to the rules which prescribe the procedure for the protection and enforcement of all claims arising from the rights and duties created by law. Remedial law is that branch of law which prescribes method, the method of enforcing rights or obtaining redress for their invasion. It should be stated that remedial law is generally encapsulated in our rules of court. Again, remedial law is basically contained in the rules of court. Circulars of the Supreme Court implementing the rules of court also contains remedial law. Now, a question may be posed. What is the nature of a rules of court? The rules of court, which is promulgated by authority of law, has the force and effect of law. However, emphasis should be made that the rules of court, which includes the rules of civil procedure, is subordinate to statutes enacted by Congress, the legislative. Thus, in case of conflict, enacted statutes or substantive law shall prevail over the rules of court or procedural law. Again, the rules of court do not originate from the legislature and cannot be called laws in the strict sense. However, as I have mentioned earlier, since they are promulgated by authority of law, they have the force and effect of law, if not in conflict with statutes enacted by Congress or the legislative department. Again, the rules of court is subordinate to statute, and in case of conflict, the enacted statute will prevail. Now let us proceed to applicability. To what types of cases is the rules of court applicable? Under Rule 1, Section 2, the rules of court shall apply in all the courts except as otherwise provided by the Supreme Court. In relation thereto, Section 3 of Rule 1 states that the rules of court shall govern the procedure to be observed in civil or criminal actions and special proceedings. It should be noted, however, that Section 4, Rule 1 expressly provides that the rules of court does not apply to the following cases. First, election cases. Second, land registration cases. Third, cadastral cases. Fourth, naturalization cases. Fifth, insolvency proceedings. And lastly, other cases not provided for in the rules of court. However, in these types of cases, the rules of court may apply by analogy or in a suppletory character only, and whenever practicable and convenient. Relevant to our discussion is the distinction between substantive law and remedial law. Substantive law creates, defines, and regulates rights, duties concerning life, liberty, or property. However, remedial law does not create rights or obligations, but lays down the methods by which these rights and obligations arising from substantive law are protected, enforced, and given effect. Substantive law creates vested rights, while remedial law does not create vested rights. Substantive law is obviously enacted by Congress, our legislative department, while in remedial law, the Supreme Court is expressly empowered to promulgate procedural rules. And substantive law is generally prospective in application. And the other side of the spectrum, remedial law may be applied retroactively. Why? Because in rules of civil procedure or in procedural law, remedial law, no one can claim a vested right because remedial law does not create vested rights. Now, on the topic of retroactivity or prospectivity of the rules of court, it must be remembered that the rules of court are not penal statutes and cannot be given retroactive effect. Again, as a general rule, the rules of court are prospective in nature. However, by way of exception, the rules of court may be made applicable to actions pending and undetermined at the time of their passage and are deemed retroactive in that sense and to that extent. The reason of this for this is because, as I have mentioned earlier, there are no vested rights in the rules of procedure. Again, as a general rule, the rules of court are prospective in application. However, by way of exception, they may be given retroactive effect. How? By making the rules of court applicable to actions pending and undetermined at the time of their passage and are deemed retroactive in that sense and to that extent. Question: who has the power to promulgate practice, the rules on practice, procedure, and pleading in all courts? It is the Supreme Court, precisely under the 1987 Constitution, Section 5, Paragraph 5, Article 8 thereof provides that the Supreme Court shall have the power to promulgate rules concerning, first, the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Again, to emphasize, the 1987 Constitution took away the power of Congress to repeal, alter, or supplement rules concerning pleading, practice, and procedure. The power to promulgate rules is no longer shared by the Supreme Court with. All right, let us proceed to compliance to the procedural rules. As a general rule, it should be emphasized that compliance with the procedural rules is still the general rule, and abandonment thereof should only be done in the most exceptional of cases. Again, generally, observance of the rules is still the general course of action as it serves to guarantee the orderly, just, and speedy disposition of cases. Now, by way of exception, is the liberal interpretation of the rules. And this is provided under Rule 1, Section 6 of the Rules of Court, which provides that the rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. Now, what does this mean? This rule on liberal construction. The rule on liberal construction involves a relaxation of the procedural rules when their rigid application would hinder substantial justice. Precisely, rules of procedure are mere tools designed to facilitate the attainment of justice. By way of example, the rules of court provides for a prescriptive period within which to file a particular pleading or motion, and the period having elapsed, no such submission was made. As a general rule, compliance with the rules, which in this case is compliance with a prescriptive period, is the general rule. Thus, when there is a failed submission within the period provided, late submission thereof will not be accepted by the court. However, this may be relaxed, and in this situation, the courts may allow belated submission in the interest of justice. However, in this instance, there must be an exceptional reason as to why suspension of the rules is justified. Indeed, the bare invocation, the interest of substantial justice, is not a magic wand that will automatically compel this court or the courts to suspend procedural rules. There should be a special or exceptional circumstance or reason for such suspension or relaxation of the rules. and it is the burden of the party seeking such relaxation to prove such exceptional or special circumstance or reason. All right, let us have a brief overview of Philippine courts. Now, what is a court? How do you define a court? A court is an organ of the government belonging to the judicial department, whose function is the application of laws to controversies brought before it and the public administration of justice. Question: is the term court and judge synonymous? No. Court and the judge is not synonymous. They are different. The court is a tribunal officially assembled under authority of law, and the judge is an officer of such a tribunal. The court is an organ of the government with a personality separate and distinct from the person or judge, being in imagination comparable to a corporation, while the judge is the person who sits on the court. He or she is a physical person. The court is an office, while the judge is a public officer. And disqualification of the judge does not affect the court, and the judge may be disqualified. Now let's go to classification of Philippine courts or classification of courts in the Philippines. Now let's go to classification according to the nature and extent of jurisdiction. First, the Court of General Jurisdiction, one which has the power to adjudicate all controversies which may be brought before it within the legal bounds of rights and remedies, except those expressly withheld from its plenary powers. In the Philippines, only the regional trial courts are courts of general jurisdiction. Second, courts of limited or special jurisdiction are those whose power to adjudicate is confined to particular causes or can only be exercised under the limitations and circumstances prescribed by statute. By way of example, the municipal trial courts, Sharia courts, and the Court of Tax Appeals. Third, the Court of Original Jurisdiction. This is one which has the power to take judicial cognizance of a case instituted for judicial action for the first time under conditions provided by law. And last one, the Court of Appellate Jurisdiction, one which has the authority to review the final order of or judgment of a lower court with the power to modify, reverse, sustain, affirm, or remand the same. By way of example, the Regional Trial Court, the Court of Appeals, the Supreme Court. And the classification of courts according to the principles on which they administer justice. First is the civil court, or that which determines controversies between private persons. Criminal court, one which is charged with the administration of criminal laws and the punishment of wrongs to the public. And the courts martial, a military court pertaining to the executive department of the government for trying and punishing offenses committed by members of the armed forces. The Admiralty Court, one exercising jurisdiction over maritime contracts, torts, injuries, or offenses. Juvenile courts, one which has special jurisdiction of a paternal nature over delinquent and neglected children. In the Philippines, this is covered with or in family courts or within the jurisdiction of family courts. Courts of equity, one which has jurisdiction in equity, which administers justice and decides controversies in accordance with the rules, principles, and precedents of equity, and which follows the forms and procedures of chancery, as distinguished from a court having jurisdiction, rules, principles, and practice of the common law. Simply stated, it is one which follows a more flexible and discretionary rules. Courts of law, which may be defined in a wide sense as any duly constituted tribunal administering the laws of the state or nation. In a narrower sense, a court proceeding according to the course of common law and governed by its rules and principles as contrasted with a court of equity. It is one governed by highly formal set of rules or proceedings. Now, it should be noted that Philippine courts are not only courts of justice but also of equity. Indeed, equity as the complement of legal jurisdiction seeks to reach and do complete justice where courts of law, through inflexibility of the rules and want of power to adapt their judgment to the special circumstances of cases, are incompetent to do so. Another classification of courts is the ecclesiastical court, or those which has jurisdiction over matters pertaining to the religion and ritual of the established church and the rights, duties, and discipline of ecclesiastical persons as such. Sharia courts, one which is charged with the administration of Sharia laws over Muslims. Now, classification of laws or of courts according to the law creating them. The first one is that deemed as a constitutional court, or the court named or described and expressly provided by the Constitution or recognized by name or definite description in the Constitution. By example, the Supreme Court. Or the or second, the constitutionally mandated court, one whose existence is provided for in the Constitution, but its creation is by statutory enactment. It is not created by the Constitution, but merely provided for in the Constitution. Okay, it is created by statute. The example is the Sandigan Bayan. And lastly, the statutory court, one which is created and organized and with jurisdiction determined by law other than the Constitution. Aside from the Supreme Court, all other courts are statutory courts. Now, classification of courts in accordance with the relation to other courts. The first is superior court, or those which have the power to review, reverse, modify, or affirm the order or judgment of a lower court. Second, the inferior court, one whose order or judgment may be reviewed by a higher court. And lastly, the classification of courts as to whether they keep a record of their proceedings. First is the court of record, one which is bound to keep a record of its proceedings for a perpetual memorial or testimony thereof, and courts not of record, or those which is not required by law to keep a record of its proceedings. Obviously, Philippine courts are courts of record. And that concludes our brief discussion on the preliminary matters and general principles with respect to civil procedure. On the next recording, I will discuss jurisdiction as it relates to civil cases. Thank you for listening, and I sincerely hope that the discussion in this recording has been helpful or at the very least informative. Thank you.